Can you mention page number 1, item 4 to 5? Page 2, item 6 to 14. Can you mention page number 1, item 4 to 5? Page 4, page 2, item 23 item to 31. 14. Page 5, page mention page number 1, item 4 to 5. Page 6, page 4, item 23 to 31. 14.
But it may be taken up 1 week after. You Lordship, I am for the
Page
opposite
5,
partner
page
1.
mention page number 1, item 4 to 5. Page 6, page 4, item 23 to 61. 14.
My Lord, but it may be taken up 1 week after. You Lordship, I am for the
Page
opposite
5,
partner
page
1.
mention page number 1, item 4 to 5. Page 6, page 4, item 23 to 61. 14.
My Lord, but it may be taken up 1 week after. You Lordship, I am for the
Page
opposite
5,
partner
page
1.
mention page number 1, item 4
No, the
to 5.
opposite party number 1.
Page 6,
No,
page
that will
4,
be
item 23
23
to 61.
the
14.
request of Mr. H.N.
My Lord,
Mapat.
but it may be taken up 1 week after. You Lordship, I am for the
Page
opposite
5,
partner
page
1.
mention page number 1, item 4
No, the
to 5.
opposite party number 1 of July.
Page 6,
No,
page
that will
4,
be
item 23 to 61. 14.
Mr. H.N.
My
Mapat.
Lord, but it may be taken up 1 week after. You Lordship, I am for the
Page
opposite
5,
partner
page
1.
mention page number 1, item
No,
page
the
6,
opposite party
item
number 1 of July.
item 37 to 40.
That will be
Item 23 to 61. 14.
Mr. H.N. Mapat.
Page 5, page number 1, item
Page 6, item
1 of July.
item 37 to 40. Page 6, item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34.
Page 6, item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34.
Page 6, item
You don't know anything.
item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34.
Page 6, item
You don't know anything.
item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34.
Page 6, item
You don't know anything.
37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name?
Item
You don't know anything.
37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name?
Item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name?
Item 37 to 40.
And when item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name? When item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name? When item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34. What is your name?
Private opposite partner.
When item 34 was mentioned, why did you say that you have given consent? PK Jana appears for the petitioner in item number 34.
Private opposite partner.
When item 34 was mentioned, why did
Very
you
moderate
say
to
that you have given consent? PK Jana appears for the petitioner in item number 34.
Private opposite partner. As filed a rejoinder
When item 34 was mentioned, why did
very
you
moderate
say
to
that you have given consent?
the
PK
rejoinder
Jana appears for the
Private officer party counsel have filed a rejoinder of 21st and interim order to correct. The rejoinder is private officer party counsel have filed a rejoinder of 21st and interim order to correct. The rejoinder is
42 to 47. Page 8, item 48 to 55. Page 9, item 56 to 42 to 47. Page 10, item 62. Page 8, item 48 to 55. Item 74, page 9, item 56 to 42 to 47. Page 10, item 62. Page 8, item 48 to 55. Item 74, page 9, item 56 to 42 to 47. Page 10, item 62. Page 8, item 48 to 55. Item 74, page 9, item 56 to 42 to 47. Page 10, item 62. Page 8, item 48 to 55. Item 74, page 9, item 42 to 47. Page 10, item 62. Page 8, item 48 to 55. Item 74, page 9, item 42 to 47. Item 62, page 8, item 48 to 55. Item 74, page 9, item 42 to
I paid 3 time to file that.
File what?
The objection filed by the public but not 2 and 5. I paid 3 time to file that.
File what?
The objection filed by the public but not 2 and 5.
The prayer of stay.
I paid 3 time to file that.
What is the objection? File what?
That objection filed by the statement. I received copy to
Ah,
but
it
not
is
2 and 5.
it is the prayer of stay petition.
I paid 3 time to file that.
What is the objection?
He has
File
filed
what?
and we have just
That
filed
objection filed by
objection
the
that in
statement.
shape of
I received
counsel, this is
copy to
Ah,
objection
it is
to
a-
read appeal, we have filed it to objection.
It is the prayer of stay petition.
I paid 3
No, I don't understand. What is the objection? Why in a
He
writ
has
appeal?
filed and we have just filed objection in shape of counsel that in
Ah,
the
it is a-
read appeal, we have filed it to objection.
It is the prayer of stay petition.
I paid 3
You are challenging the question of mental objection. Why in a
He
writ
has
appeal?
filed and we have just filed objection in shape of counsel that in the
Ah,
read appeal, we have filed it to objection.
It is the prayer of stay petition.
I paid 3
You are challenging the question of mental objection. Why in a
He
writ
has filed
appeal?
and we have just filed objection in shape of counsel that in
Ah,
the
it is the
read
factual
appeal, we have
aspect of
filed
the
it to
matter.
objection.
It is the prayer of stay petition. You are challenging the question of mental objection. Why in a
He
writ
has filed
appeal?
and
You
we
are
have
very
just filed
objection.
objection
While we are re-replication, if you want to bring some new facts before this court,
Because this is
withdraw this objection. Can you file such objection? Withdraw the objection. While we are re-replication, if you want to bring some new facts before this court, respondent. Withdraw this objection. Can you file such objection? Withdraw the objection. While we are re-replication, if you want to bring some new facts before this court, respondent. Withdraw this objection. Can you file such objection? Withdraw the objection. While we are re-replication, if you want to bring some new facts before this court, respondent. Withdraw this objection. Can you file such objection? Withdraw the objection. While we are re-replication, if you want to bring some new facts before this court, respondent. Withdraw this objection. Can you file such objection? Now you are objection. While we are re-replication, if you want to bring some new facts before this court, respondent. Withdraw this objection. Can you file such objection?
Earlier the petition was accepted for the work for a sovereign adjudication, and he is the highest mark man. That is page 47, annex 8 man. Earlier that petition was accepted for the work for a sovereign adjudication, and he is the highest mark man. That is page 47, annex 8 man.
In your retaking, there is a
And he is the highest mark man.
in
That is page 47, annex 8 man. Inside the
your retaking, there is
application. And he is the highest mark man.
so it is annexure 8 of the annexure 2. In your retaking, there is so it is annexure 8 of the annexure 2. In your retaking, there is so it is annexure 8 of the annexure 2. In your retaking, you have received a copy of the notification.
Item 5.
On 6, have you taken step or no? This is the first time it is coming to the notification. You have received a copy of the notification.
Item 5.
You have received a copy of the notification.
Item 5.
Have you brought the records? You have received a copy of the notification.
Item 5.
You are appearing to the university now? Have you brought the records? You have received a copy. You supply a copy to Mr. Kuntia and also you are appearing for the university now. Vidya Bhushan. You are Mr. Vidya Bhushan. You brought the records. You have received a copy. You supply a copy to Mr. Kuntia and also you are appearing for the university now. Vidya Bhushan. You are Mr. Vidya Bhushan. You brought the records. You have received a copy. You supply a copy to Mr. Kuntia and also you are appearing for the challenging the order. Vidya Bhushan. You are Mr. Vidya Bhushan. You brought the records.
This matter has come before this honorable bench for the first time. If the lordship allow, may I please to fact.
Mr. Kuntia and also that is the reason why you challenge the order to learn a civil judge. You are Mr. Vidya Bhushan. You
But the
brought the
civil
records.
judge has at page number 13 directed the universe if the lordship allow, may I please to fact. Verse 14. That in the event it is found that
Challenge the order to learn a civil judge. You are Mr. Vidya Bhushan. You
but
brought
the
the
civil
records.
judge has at page number 13 directed the universe if the lordship allow, may I please to fact. If deciding that in the event it is found that
Challenge the order to learn a civil judge. You are Mr. Vidya Bhushan.
decision of civil judge has at page number 13 directed the universe if the lordship allow, may I please conduct if
That is why I'm asking you, why are you challenging this order? Challenge the order to learn a civil
without
judge.
challenging that order, we discharge their action. We will say that we have taken admitted the petitioner under
That
party
is why
number
I'm
4
asking you,
as per
why
the
are you
scheme.
challenging this order? You are now show us how the
Without
order is
challenging
wrong.
that order, we discharge their action. We will say that we have taken the person's cannot be found to prove under party
That is why I'm
number 4 as
asking
per
you,
the
why are
scheme.
you
Then
challenging this
at
order?
least I should have been
You are
impeded
now
as a
show us
party
how the
without
order is
challenging
wrong.
that order, impeding me as a party. We will say that we have taken the admission to his opposite party under party number 4 as per admission and guidelines. I should have been impeded as a party without challenging that order, impeding me as a party.
You mean to say the petitioner was lower in merit than you? So if he was to be considered, you should have been given a right of hearing.
Definitely, my lords. My lords, the rank list is at page number 28. Let's kindly have a glance that I am at rank 59. Whereas the opposite party number 4 was
What
at
is the
rank.
stage of admission now? It's all over.
Because we don't have any, university has no control so far as the admission is concerned. Government of Orissa is controlling by on both sides. He is declared to close the admission process. Therefore, he closed. And as view of the direction of the Honorable Court, we are admitting the 2 persons by Lordship's order only. Because government.
No, then our query is very simple, whether the 2 persons you are just now accommodating,
Yes.
whether merit-wise they're below the petitioner or not.
Yes, yes.
They're below the petitioner.
Both are only one. He says
One, my
One.
lords.
without verifying, you're saying yes, that means the other person also has to be implicated as a party. He says only
No,
one.
he was not a party before this.
He says only one.
Who is appearing for the state, I think, Mr. Kuntia, one thing, can you accommodate the petitioner?
We have no role in accommodating. If university wants, they can accommodate.
No, I understand that. But
But
one vacancy is, if available, if you accommodate him, because otherwise we have to interfere it.
Yes, my lord, your lord. If
Someone in the merit list in the higher position cannot be ignored. And 2 other person below that, then we have to.
yes, may I permit to
Past
ask a
semester
question?
already over. In the meantime, past semester has already been over.
No, that if they are interested, that we can direct, because first semester, you can also make up, I think. There is a process of supplementary examinations.
4 seats are vacant as,
4 seats is vacant.
so he can be accommodated.
Ah.
Subject to condition that 1 semester is over, that part your lordship have to take.
All right. That is why we'll take the assistance from the register
Yes.
before us. Otherwise, we have to interfere with those students are already admitted. We
Yes.
don't like to disturb them.
My lord.
Otherwise, university also will find filling up of this vacancy will be left unfilled. So only good alternative is to allow the persons who has been superseded in merit.
Yes,
He should be allowed to be admission. And you also take the instruction from your client whether he is ready to.
My lords, he is ready. But my lords, one thing I want to submit
Yes.
that my lords, this one admission, my
Yes.
lords, actually after the closure of admission, total 6 seats remained vacant. Out of that 6 seats, 5 was for general and 1 was for SC. Now that on 1 SC seat, the opposite party 4 has taken admission. If they have no problem accommodating me, I am a SC candidate. accommodate me in the general category, then I have no
No,
problem.
no, there is no question. They will just rearrange because if the SC6 has vacancy now, they will transfer these vacancies. That person who is a SC was just accommodated, was not, you are not accommodated, you will be accommodated against the SC seat. And the person who has been shown to have accommodated against NC
That person is also SC, my lords. That OP number 4 is also SC.
Oh, then they can, because vacancy, there is no issue.
No, you were saying only one vacancy was there.
SC seat, yes, my lords.
He has
So
taken it.
yes, my lords.
And your merit position is relating to the SC candidates,
My lords.
or it is a combined merit position.
No, my lords. Kindly have a glance at page number 28.
Okay.
There is some other person also above the list. Some other person also above the list.
Yes, my lords.
Some other person also in merit position is there.
Yes,
You were at serial
My lords at 59.
59.
and that OP4 was at serial.
My lords 64.
That
OP4.
means, there are 3 more in between.
Yes, my lords. But as per my instruction, subject to verification, I'm 100% sure that this, my lords, Saubhagya Lakshmi Sethi, 58. My lord, still 54. The SC candidate at 54 is already admitted. Now the one candidate is above me, that is Saubhagya Lakshmi Sethi. This lady has taken admission at Puri SCS College.
No, we are not
Puri Law
concerned
College.
because we are
my
not
lords.
concerned.
Because,
It is not also the concern of the university also.
okay,
This kind of borders only creates. You are not made party there also.
No, my lords. In writ petition, I was not party.
That means he should have made 10% as party. There were 10% above him as in the merit list.
My lords, above me.
No, above him. Above OP4, there were 10 persons.
Who are the persons who have been admitted?
Up till 54.
My lords, including general and SC both. Because the admission is related to SC only. So, my lords, SC candidates will only be considered for SC seats. So, above this person, OP number 4, I was the first person. Immediately above OP number 4, Suman Malik.
I'm not talking immediately.
Suman
last-
Malik was the writ petitioner.
The last candidate and the OP4. How many candidates? How many SC candidates?
Just ask the register whether for if the court, any role of the state government is there for the admission. Because the last date is there, because they have to also relax the last date, otherwise you cannot do that. That is the position, I think. Just come forward.
Admission process has already been closed since 30th November.
Because session has started.
We have no scope to admit only in order to honorable.
And when that this Sumanta Malik was admitted, Suman Malik,
1st February, sir.
first,
1st February.
that is also 3 months after the last date.
That the order we have received in 21st January, then we make the admitted on the 1st February 23.
In this matter, no notice was issued, I find.
Yes.
Notice was issued, my lord, sufficient.
20th March notice was issued.
Notice
All the
was
parties.
issued.
Okay, Mr. Chiranjeev,
My lords.
53, 54, 58, 59, 64 are the SC candidates. 53 has been admitted.
53, 54 has been admitted. Only,
No, you said somebody has gone to SCS
my
Puri
lords, 58.
58
has
has
been
gone.
Puri, my lords.
and you are 59.
59, my lords.
Okay, so then there is no problem.
No, yeah, exactly.
But general candidates,
It means that before you, everybody is admitted.
Before me, yes, my lords, exactly. Now, my lords, the situation may arise that 4 seats is general. Now, general candidates can also, my lords, say that give us also admission in that. It is actually, my lords, the
In fact,
order was,
don't they have the practice of if vacant seats fall vacant, they invite students and give them admission? Don't you have that practice? If the vacant seats are there, so you'll keep the seats vacant.
one website has been prepared by the state government once. So as per direction of the higher education department, the once has serialized all these candidates and they are close the website and fix the date. Therefore, we are not able to admit.
Or not the usual practice which was there earlier.
Now they are now implementing set.
May I, my lord, say something? My lord, this my learned senior has stated everything right, but this admission means that spot admission is absolutely in the hands of the college.
That is what I'm asking.
That
What
is
my
the
lord?
direction.
SAMs,
On the
my lord,
ground, spot
initially
admission.
for the first, second round, SAMs give the names.
Yes.
Thereafter, my lords, admission closes. Then thereafter, what happens? What happened in this case? My lords, every year the rules change. So what happened this year?
Appearing for the respondent number 4. Notice was issued. Nobody is appearing.
So what they said, no, that is incorrect. That means they have this procedure of spot admission still now.
My lords.
No,
No, what?
Then how was this person?
Because of lordship direction, we are complaining.
Then what are you saying, Mr. Chiranjeev? That
On
is
the basis of
because of the
lordship
court's
direction, we are complaining.
decision.
My lords,
Authorized will not admit
kindly turn to page 26.
Yes.
After a certain time limit, my lords, the state government delegates the power to the universities. Now you call the students who are interested.
Where is
to
it?
take, my lord,
Where do you
26. 26, my lord.
26 where?
My lord, admission notification.
Okay.
This, my lord. CPD 2022 appeared candidates in law who are interested to get themselves admitted in Madhusudan Law University. Means at this stage, what happened? Every University of Odisha issued a notification in newspaper calling the candidates to come to our college and take admission. Now, on this notification, 80 candidates applied in Madhusudan Law University. Means randomly they applied. Now there means the marks does not at that time state government has no role. On the basis of that 80 candidates, a rank list was prepared. That rank list is page number 27.
Okay, all right.
No, this is clear that you did not reach because that the vacancies at that point of time after this notification on 2nd of November 2022, you were not there in the list for admission.
I was there, my lords. I'm at page number 20.
Your position was shown by the university according to the merit, but vis-a-vis the vacancy at that point of time, there was no vacancy available to give you.
No, there was vacancy, my lords. There was vacancy. That's why this list was prepared to intake students from this list only.
Vacancy may also be there if some student after admission goes to another college. These are the sudden vacancies. We do not know how those vacancies arose.
Now, what do they mean by participate? It is not stated that you come and take admission. It is stated you participate.
Yes, my lords.
So participate
I
means all
applied-
will be given. Then that means all will be given admission, or the ones who appear.
Appear means, my lords, I do not understand.
You mean to say that list which was published of 80 candidates, there were 80 vacant seats.
No, there was
Then-
no 80
then-
vacancies. There
then-
was, my lords, just a minute, 19 vacancies.
So it is first come, first serve.
No, my lords. Otherwise, if it is first come, first serve, then why the rank was prepared, my lords?
Because if 6 people come and there are 4 vacant seats,
No,
the
my lord.
first
I
4
am
will be-
clarifying this point, my lords.
Just clarify my doubt.
Your lordship, see the government of higher education department later. That will clarify everything.
No, this is the date. This is the date for the counseling to just weigh whether they satisfy the standard, and now the vacancy can be offered to them.
All candidates.
This is
No,
later.
This is not that they will come and they will get admission.
Yes, that is the letter which has not the government higher education department issued all these college and universities. And it closed on 30th November. Website has been closed. Even the vacant seats are there, we are not able to admit anyone, even in spot.
My lords, on 30th November 2022, when the entire admission closed, all the students took admission, means Madhusudan Law College, 80 seats were completed.
No.
No,
It may not
I'm
happen.
coming, my lords. It was completed, but there is a condition that if someone has taken admission from other college or has not paid the admission fees, then their candidature will be cancelled. So after this date, it was found that 6 seats were lying vacant for these 2 reasons.
These are consequential.
Consequential, my lord. So now these 6 seats were lying vacant. So ideally, it should be left untouched. Means if that is the procedure, then it should be left untouched.
Now we are concerned with a very small question. First of all, someone by you have the judgment of the court has been admitted. Your challenge is very limited. You say I should have been also considered. before this person's admission. I belong also to the scheduled caste category, but I was not considered. I was not even given notice. So someone stole the march over you, so you are aggrieved. You have a right to file the writ appeal, you have filed it. We are finding a solution without disturbing someone's admission.
Definitely, that will be, my lords. That will be
Because otherwise you'll be thrown in an uncertainty only.
my lords. I have no intention to, my lords, to actually to just hold on and
that is why
cancel his.
our concern is whether any way you can be accommodated by way of an admission. Only embargo in this process is that the seat was earlier where this petitioner was accommodated. It was a SC category candidate.
My lords, yes, exactly.
Now there is no SC category candidate after his admission.
My lords, exactly.
Right?
Exactly.
So he is to entertain against a general category.
Exactly.
There will be some legal problem.
Exactly. My
Because
lords.
if we open that Pandora's box, the general category candidate will say how he can be accommodated
Exactly,
the
that is what it is.
seat allotted for the general category. Right.
Exactly.
So what is your answer to that?
It's a very difficult question, my lord. That is why I've come before your lordship. I'm not judge, my lords. On this.
There is no SC vacancy at all now. Whether there is any SC vacancy after reconciliation? No.
1 minute, sir.
Just check up. Madam, you take time. You take up to 5 minutes. Just you take time. The records in matter will be taken up to 5 minutes. Let us consult the records. Okay. Call the next item.
Item 6.
May I please, Lordship? My lord, on last occasion, Lordship directed my learned senior to obtain instruction whether the examination has commenced or not, my lord.
So the preliminary examination is over.
As it appears that main examination will be held either in August or September. May I pray this matter can be finally disposed of if your lordship fix any dates without passing any interim order. His interim prayer to allow him to the recruitment examination.
No. Therefore, for participating in the main examination.
My lord, no. I have not been allowed
I'm
to
not-
participate in the preliminary
Bob has
examination
been
also, my
rejected.
lord.
Because as per the advertisement, he does not satisfy the qualification.
Come to that point, we'll decide that point. Because
Yes,
we
so
cannot,
that
yes,
I'm-
you make your submission.
Yes, my lord.
Last order, we have also observed that it will be hard
Yes,
if
ma'am.
it is required. We'll hear you. How do you satisfy the requirements of the
Yes, my lord.
advertisement?
Lordship, may I for a moment kindly have a glance at the advertisement issued by the Odisha Staff Selection Commission, that is Annex 2.
Yes.
My lord, recruitment for 7,540 posts of regular teachers for government schools were notified by the Odisha Staff Selection Commission.
So
Lord-
you fall in the level 9.
Yes, my lordship, kindly have a glance at that minimum education qualification. I am an aspirant for Sanskrit teacher, my lord, and my
This is why
qualification.
you are in the level 9.
Yes, my lord.
Where is the Sanskrit teachers?
Page 34. Lordship, may come to page 34.
The serial 5.
Yes, my lord. Serial 5. Qualification, they have prescribed bachelor's degree with Sanskrit as one of the elective oblique optional oblique honors pass subject from a recognized university with minimum 50% of mark in aggregate, and Shiksha Shastri, a course prescribed by NCT from a recognized university institution, BEd from any NCT recognized institution, my lord. But my qualification is I'm MA in Sanskrit, my lord. And my lord, the qualification they have prescribed is contrary to the NCT guidelines. For a moment, lordship kindly have granted the NCT guidelines, that is page 50, annexure 4.
NCT guidelines is the guidelines.
Yes,
what is
my
in the recruitment rule, Mr. Kuntia? What is there in the recruitment
Yes,
rules?
that our guideline, that we have no 309 rule. We have issued a guideline, and as per the guideline, this advertisement has been issued.
Issued.
But they have to follow the NCT
And they have not
guidelines.
challenged.
Just NCT guidelines.
Yes, my lord. For a moment, kindly have a glance at page 55.
Ah,
Page 55 for a moment. My lord, applicability. Applicability of the NCT rules, my lord. These
page 55.
page 55, my lord. That is annexure 4, page 55. It starts from page 50, but lordship may come to page 55.
Yes.
Got it, my lord? Applicability. These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, or senior secondary, or intermediate schools, or colleges imparting senior secondary education, my lord. This is applicable throughout India, my lord, and they have to follow. And my lordship kindly have a glance at the first schedule, the qualification that is prescribed for the classical teachers. For all category of teachers, my lord, they have made two schedules. One is first schedule and second is second schedule, my lord. On the first schedule, lordship kindly have a glance at, that is the National Council for Teachers Education, determination of minimum qualification for persons to be recruited at educational teachers in pre-primary, primary, upper primary, secondary, senior secondary, intermediate school or college, regulation 2014.
You come under the intermediate?
My lord,
You
no,
come
I
under
come under secondary, my lord.
senior secondary
Yes, my
intermediate.
lord. Lordship, last line, my lord, that is point number 4. Secondary high school for classes 9 and 10, my lord. And lordship kindly see the qualification they have prescribed.
The Sanskrit teachers for the class 9 and 10.
Yes, my lord. Lordship may kindly have a glance at the qualification. Graduate oblique postgraduate from recognized university with at least 50% of marks in either graduation or post-graduation or its equivalent, and Bachelor's of Education from National Council for Teachers Education recognized institution, my lord. This is the qualification. My lord, so far as the qualification prescribed by the Odisha Staff Selection Commission is concerned, my lord, they have omitted this postgraduate, my lord. My lord, they can go beyond these NCT guidelines, but they cannot go below the NCT
So
guidelines.
You did not get the graduate 50%?
No, my lord. In graduation, I don't have 50%, but in post-graduation, I have 50%, my lord.
But he has 50%.
No.
In the read petition, you also see para 3. In that read petition, I am not saying read topic. In the read petition, lordship can find it from page 65. So page 66.
Page 66.
Paragraph 3.
Well, that is not the ground why my case has been.
No, just a minute. Let him
Sorry,
get the opportunity. Page paragraph 6.
Paragraph 3, my lord. That so far as the qualification of petition is concerned, she has passed BA with Sanskrit honors with 50% mark from Utpal University.
So what are you submitting that is completely against the above-ments?
My lord.
Read your paragraph 3 of the read petition.
Man, in total, I have got 50%, but in honors, I have not got 50%.
Sorry, madam, he has not also secured 50% in aggregate. The lordship can find it from his mark sheet. He has annexed it. The lordship may see page 74.
If he doesn't get 50%, will he have get honors?
No, yes. The lordship may see page
No. That averment, BA with Sanskrit honors.
with 50% mark.
So
our requirement is 50% in aggregate. He has not secured 50% in aggregate. Your lordship may see page 74 is mark sheet. Or mark sheet.
So he got 50% in what? Nothing.
Nothing. Your lordship may see that page 74. If has secured 50%, then he fulfills the eligibility criteria.
No, no, I'm saying.
Page 74.
Full drafting.
The grand total, you can find it, the grand total is 824. Total mark is 1800. You got it?
Yes,
Page,
yes.
Page 74.
So it comes below 50%.
Yes, ma'am. 50% is 900.
But my lord, my case is different.
All right, we'll look into that. Now, suppose there is a case that is he has also secured the postgraduate degree with 50% mark.
Yes, then I'll come to that. You'll also may turn to page 137.
All right.
This was the resolution basing on which staff selection commission has issued the advertisement. This has not been challenged. You'll also say page 137. LRC can find it that educational qualification at page 145.
Yes.
LRC got it that classical teacher might. Bachelor's degree with Sanskrit as one of the elective optional pass from recognized with minimum 50% mark in aggregate. So that was the resolution that has not been challenged, and on the basis of this resolution, advertisement has been issued.
But according to the NCT regulation,
NCT says either graduation or post graduation. We have fixed it to post graduation. So that he cannot say that you fix it for post graduation also. Either or. We have accepted one.
My lord.
Post graduation is not matter. We have to accept
go below
either
the NCT guidelines, my lord. They can go beyond the
we cannot
NCT guidelines.
Go below
To improve the
50%.
standard of teaching.
50% in graduation.
no, the question is whether the state government is competent. They have not taken any action which is in contradictions to these NCT guidelines. Number one.
Yes,
why
ma'am.
I'm telling you, it says the graduate or postgraduate. They say we will not take the postgraduate, we will only
Yes.
take the graduate. Whether that the leeway is available with the state government or not. That is the issue, whether they can do. Fundamentally, education is still a subject matter of the,
Yes, ma'am.
the part 2 list.
Yes,
So,
My lord, for a moment, kindly have a glance at the applicability of the NCT guideline 2014. My lord, that is page 55. Again, I will read it, my lord, that applicability. These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school, imparting, my lord, in any recognized school, imparting pre-primary.
we read it together. My question is somewhere else.
Yes, my lord.
Someone it gives the alternatives.
Yes, my lord.
Slant means alternatives.
Yes, my lord.
Now state government accept one, not all the alternatives.
Yes.
Whether it is the violation of this applicability clause. Suppose there are certain qualifications are there.
Yes, my lord.
I want to take the young teachers. Suppose
Yes,
I'm
ma'am.
giving. This is a comparatively young age.
Yes, my lord.
I will not take the postgraduate for various other reasons. Can state government just regulate that way or not? That is the issue in this case, very
Yes, yes.
important.
My lord, then, my lord, I will cite some judgment. I will cite some.
Come on the 27th,
Yes, my lord.
Harding part. Let the matter be listed on 27/7/6/2023 for continuation of hearing. Mr. P.S.Y. when council appears for the Mr. Kumpiya for the state respondents. Just sure. I think this is an issue, and
Yes,
very
ma'am.
important issue, I think. The
Ma'am.
applicability does mean that the entire thing is accepted.
ma'am.
Because ultimately the state government always came to the local condition without violating the
Yes.
basic tenet of the guidelines.
Without relaxing any condition. We are not relaxing that 50%.
But you are regulating.
Yes.
But they're excluding, my lord, one part, my lord. They're excluding. And my
that
lord,
is
there is
what-
my lord,
that
there is a
will
judgment
show.
of this honorable apex court
I
that
think
they
there
can
is
go
one-
beyond the NCT guidelines, but they cannot go below the
I
NCT
think- I
guidelines,
think
my lord.
This is a decision of, I think, of 2014. or
Yes,
like
my
that.
lord. That day also.
Just check up their judgment. Siddharth Hazarika versus State of Assam.
Yes, ma'am.
The judgment.
Deeply obliged, my lord.
Right. Next, this matter.
Item 5.
My lord, you will also kindly just searching. I have telephoned the university office. You check out the fetal list. Some time
Some other day. Some other day.
As a reason.
27th is fine, or in the month of July, because we are not trying to delay the matter.
Correct. Yes, career of a students. We don't want to also delay.
3rd of July,
Third.
you come prepared.
Yes.
This,
You find a way out for us.
Yeah, highly written note. Let's keep it that.
You are appearing for whom?
This note so far as the.
we'll keep it.
Yes, that you will also keep.
You doing 2 sets or 1?
2 set I have given.
Okay, এটা আমারও তাহলে।
Mr. Satapathy, counsel appearing for the opposite party number 2 has prayed for accommodation in order to scrutinize the records properly in order to ascertain the vacancy position vis-a-vis the reserved category. Stop. In terms of our order dated 2023, what is your good name, madam?
Sir, Nirupama Swain.
MS Nirupama Swain. The registrar, Madhusudan Law University, has appeared in person and assisted the court in the proceeding. If we ask you to come on the next date, it will be very difficult for you to come. Otherwise, you just instruct your counsel. We are not reflecting that your presence is required. We are dispensing your presence. But if you want to come, you may come. Okay. The attendance of the Registrar Madhusudan University is dispensed with. So Mr. Chiranjeev Vidyabhushan Learned Counsel has appeared for the petitioner. And he has stated that the writ petitioner, the respondent number 4 has been accommodated against the last vacancy available for the SC category candidate. But the petitioner, but the appellant is in the higher merit position in the SC category. Stop. As such, he has stated that as the appellant was not made party in the writ proceeding, the impugned order is liable to be set aside. And if the admission is to be granted, the appellant has to be given precedence over. All right. Mr. Kumtia, just you record Kumtia's name for the state responsible. Kumtia is appearing for respondents number 1, 2, and 3. You are for 1, 2, and 3.
Yes, ma'am. And for
This first there is an order.
Opposite part
Objection
number
was
1.
made. That was withdrawn. To reflect that it is taken by Subhasis. Then
Opposite part number 1 only.
Huh?
Opposite part number 1.
Only 1, 2,
Yes.
3 can also appear, I think.
At 2, 3, my son senior is appearing.
Register now.
No. You are for 3.
I can also appear for 3.
Yeah, 3 you can have.
1 and 3. Sam's
No, is it 2? Is only for 1.
Sam's.
All requested on the file.
That means you are not heard before the learned single judge.
No,
You are not
I've
there.
missed the list, so though I have filed the counter affidavit, but later on. The state presence, it was passed.
But you have not challenged the order.
Subhasis is for the opposite party number, respondent number 2. 3, nobody is representing 3, I think, 3 and 4.
I am for 3, 1 and 3.
Oh, 1 and 3, this is all right, 1 and 3. None appears for the respondent number 4, despite notice from this court. All right. When the date has been given, 3rd of July.
Item 7.
Free copy of your.
Free copy of this order is supplied to Mr. P.K. Subhasis. Just, let me counsel appearing to the response number 3. Oh,
6.
Paul?
Item 7.
Yes.
May I please your lordship?
Yes.
My lord, the case of appellant is for correction of mistake in answer key for question number 10, 97 and 100. But the Honorable Single Judge has been dismissed the writ application on dated 21/2/2023 on the ground of revaluation. Sorry. My lordship, the brief fact is that the appellant is a meritorious student and appeared the Orissa Homeopathy Medical Service on dated 29/1/2017, which was conducted by OPSC Orissa Cuttack. In this examination, 3 marks has been given correct answer, but opposite party has been wrongly marking the answer key number 10, 97 and 100, by which the petitioner deprived for getting just 3 marks.
The answer key contained the wrong answers.
Yes, my lord.
Have you filed the representation before the board, selection board? Without filing the representation before the selection board, how can you straight come to the High Court? You want a writ of certiorari to be issued in a matter when they might have a say. The answer key containing wrong answers, it is the affairs of this board which is holding the selection process.
Yes, my lord.
You have not represented before them, you are coming straight to us. How can you extend our jurisdiction? Tell us.
My lord, give some time for proper preparation, my lord.
It is expected that when you are not properly prepared, you should not start submitting. When the first question I give, you need preparation, and this is the sole question that has to be asked to you. All that it will come on 5th of July. Who is appearing, Mr.
Yes.
This young counsel perhaps could not get this point.
Yes, ma'am. What has happened in this case, I am appearing for the state government opposite party number 1. So that
you have nothing to do much.
Yes, ma'am. There is nothing, my lord. If there is any error in the question, he should have brought to the notice of.
No, just the question is that when the answer key is published, you just take the instruction from them. Whether
that OPSC had to say that they have separate counsel. We cannot take instruction. OPSC.
Oh, there is a separate counsel. Why you are made party there?
Only formal party, state is a formal party because this is the appointment is to be done by the government. So we have been made a party. Selection is to be conducted by that.
Whether the answer key was published? Do you know the process?
Yes, my lord.
Do you know the process?
No, my lord.
Then how will answer?
Kindly give me some time for.
No, whether the Annexion 9 was published, inviting an objection. You take the instruction properly. I am telling you, when this examination on the MCQs held, It is not actually evaluated by the human beings, right? No evaluator, human being evaluators are there. They evaluated by the optical readers. On the basis of the answer key, the computer will be instructed, these are the correct answer, and optical reader will go over the answer scripts, and accordingly evaluation will be complete. So everything depend on the answer key.
My lord.
Right?
Yes, my lord.
So this is the usual process that is followed by all the selection commission or the board is that after the examination is over, the answer key is published. Against the question, what is the answer? That will be for that purpose, that will be evaluated on the basis of that answer. It is published. So if someone finds that the answer in the answer key is not correct, or maybe there can be any other alternative answer, they can raise the objection. So on the basis of that particular selection commission or the selection board has to take a decision what they will do. If your contention is correct, they can decide even though have answered this, we'll give them the equal mark. Then it will be a controversy. If you do not object, we will not entertain such application. As simple as that. We have other businesses to do. They cannot outsource their process to the High Court. So prepare very well when it is fixed.
So you have to find out whether that answer sheet was published after the examinations. All right.
Yes.
All right. Your good name is?
Priyanka Mahapatra.
You are there on record. Yes, MSP Mahapatra. At the request of MSP Mahapatra, Learned Council, let the matter be listed again on 5th July 2023 for considering admission of this appeal. Mr. Kuntia, government advocate, appears for opposite party number 1 on advance notice. All right. Come prepared, otherwise it will be shut down at the threshold.
Obliged, my lord.
Item 8.
8, 9,
Item?
and 10. 8, 9, and 10. All are similar matter. On where Mr. Das kindly pass over.
All right. Pass. You wait for some time in the courtroom. What to do?
My lord, sir, I'm told that your lordships are not sitting after lunch.
Huh? No, at 2 will not be sitting.
Monday, my lord.
Monday, there is no time, then we fix on 3rd of July.
No, but
If there is urgency,
my lord, my habit on if Monday is not that on 27th, my lord's my habit.
just fix on 27th. Your name is?
Sangram Jain. On behalf of Mr. Samir Das. SK Das.
Mr. S. Dev, Learned Council, appear on instruction of Mr. S.K. Das, Learned Council to the appellant. Let the matter be listed on 27th of July 2023. Now, Mr. Kuntia, you are appearing?
Paper statement.
Additional government advocate.
I am for opposite party number 1 and 2.
Opposite party number 1 and 2. And you are appearing for the 4. You are appearing for 4 or 3. Governing body or?
No, respondent 4. My lord,
I am for respondent 4.
You have filed the Vakalatnama.
yes, last occurrence.
Appearance I have already filed.
You have Mr. J.K. Roth.
I
Mr. J.K. Roth, right. Senior counsel, has appeared for the opposite party number 4. All right. Come fully prepared on that day.
Well,
Writ appeals in admission, we are very strict.
well,
Because someone's right already determined by the learned single judge, that will get deferred.
Well.
So we'll decide it as, we give a very complicated questions, of course we'll admit and hear the matter at full length. Call 9. 9 what, same prayer?
8, 9, 10. So
Same.
all are got a common judge.
All right, same order, just copy this order. 11.
Item 11.
On behalf of Mr. Bhuya, this matter was one with actor.
And in this case, madam, I am appealing for the respondent. The appeal is not maintainable on the ground, my lord, that the Lawrence single judge has exercised its power under Article 227.
Are you sure?
Yes, that is reflected in the order. That is reflected in the order of the learning single judge, my lord.
All right, show us from the judgment.
My lord.
Annexure 2.
Annexure 2, my lord.
Yes.
Last paragraph of the order, your lordship will
No, just first come to these reference above the cost title. An application under Article 226 and 227 of the Constitution. It starts.
But the exercise of the power by.
Show us these specifications.
Your lordship will kindly turn to page. That is, my lord, internal page 5 of annexure. Again, the order of the election. Annexure 3, annexure 2, my lord. Annexure 2, page 78.
The impugn order is order of the election tribunal.
Yes, my lord.
Then
the election tribunal, that is two types of, one is, my lord, you can challenge on 226.
All right. So it is a case of dismissal. Court refused to exercise the power of 227.
Yes, ma'am.
Whether the refusal is correct or not, whether the order is passed under 227.
It is the exercise power under Article 227, my lord.
He refused to exercise the power under 227. Is it an order under 227?
Yes, my lord. Because of the fact that,
your contention should be that jurisdiction invoked by the petitioner is under Article 227. Whatever order is passed, it has to be deemed to have been passed under Article 227.
That is why
suppose one court refuses to pass an order under 227, it can be amenable to the appeal by writ appeal also. You just check up the Supreme Court, all the series of decisions are there. Yes, show us.
Civil matters are concerned when civil court is concerned, it is totally bar. It is totally bar, man.
You are referring to Chayanath 2014?
No, ma'am. I am referring to the decision by Honorable Justice Deepak Mishra. After that full bench decision, ma'am.
No, there is one decision exclusively deals with the matter.
15.
9 is.
What is the name of the parties?
Jogendra Singhji.
Just read that part. What the Supreme Court observed about that there can.
Import of the order to be seen whether it is passed under Article 226 or 227.
That is why I am referring to the application was filed under both under 226 and 227.
That has also been discussed in this decision, madam.
All right.
Even it is nomenclature is 226 and 227.
All right. Can you argue the matter right now? Because if it is an order under 226, court will pass just one-liner order. That is not maintainable because in a
227.
In a 227 matter, the division bench cannot be the appellate authority.
Pass over the matter.
Pass over. When you will come back?
My senior is arguing another court.
That we are sitting on the first half only today. So it is now almost 11:45. You come by 12:15. All right. Because the law is very settled since long. It's since 1969. Then there is a good decision in 1984 also. Now, Ms. Mahapatra is also referring to that how the letter patent appeal will not be entertained because if the order is passed under Article 227. So come prepared, tell your senior that the appeal is not maintainable because the order was passed under Article 227. And I find here this High Court also and several High Court also, these applications are filed 226/227. They are not sure which jurisdiction they are invoking.
Yeah, all the application, we are writing 226 to 27.
You should not do that. Because usually you do not read the cause title at the time of passing the first order in the constitutional courts. Otherwise, you have to be very careful, look into those things. Then we write, this is a writ petition under such and such. Start first order, first line should be like this.
And second thing, my lord, in 227 only annul the order. 227 is the further direction is issued.
Now, this is the subject matter of the case because it is relating to this election tribunal. It is only 227. That's all. That is usual. That is why I was just asking you to find out this Chayanath case. This is written by, authored by Justice Adarsh Goyal.
So that is a larger bench decision. That is a larger.
Radhesham or which one that?
This is a 3 judges bench's decision. This is Chobinath, not Chayanath. Chobinath versus
Radhesham versus
Chobinath. Radhesham versus Chobinath.
This decision also relied in this case.
No, they have also stated that from any tribunal or this judicial order, Article 226 will not lie. All right. You come at 12:15. Call this matter as 12:15. Pass the information to your senior. The matter will be again called out in 12:15.
Item 12.
May it please the lordships. The order passed by the Honorable Single Judge under Annexure 11 is under challenge before your lordships on 4 counts.
Yes.
That's my first count is, my lord, once an appointment is made from the select list schools, it was not considered by the Honorable Single Judge. My second leg of submission before the Honorable Single Judge was that no appointment over and above the post advertised can be given. In the instant case, my lord, the post advertised for the ST category were 2. The appointments were given to 6 persons. Number 3, my lord, as the law laid down in Tejpal Singh and my lord Puspa and subsequently laid down in 2016 Supreme Court 1098, that says, my lord, once a caste certificate is filed at the belated stage, but before appointment, it ought to have been considered by the employer. Number 4 was on merits, my lord. On merits, I stand at a better footing than opposite party number 3, 4, and 5. I award that in the writ petition, doctrine of non-traversal, my lord, state did not deny in its counter affidavit that I was less meritorious. That has also not been considered. Lordship may kindly have a glance at the impugned order first. Annexure 11.
I think there are a lot of private respondents.
My lords, there are 3 private respondents, opposite party number 3, 4, and 5.
Who is appearing for the state, Mr. Kuntia? We find this, we should admit this matter.
Yes.
You are Mr. P.K. Khuntia?
My lord, I am Kalpataru Khuntia. K. Khuntia, my lord.
K. Khuntia, okay.
Yes, my lord.
Heard Mr. K. Khuntia, learned counsel appearing for the appellant. Admit. Call for the records of WPC number. Annexure. Petition number is?
WPC TAC, my lord, this was transferred from the state administrative tribunal after its abolition.
Just a minute.
WPC TAC number 40(C) of 2014.
WPC
TAC.
TAC 40/2014.
40(c) of 2014.
14. Stop. Issue notice. Since Mr. Khuntia, an additional government advocate, appears in which notice for respondents number 1 and 2. No formal notice is called for in respect of those respondent. But Mr. Khuntia and counsel for the appellant shall supply 1 additional copy of the memorandum of appeal to Mr. Khuntia.
I also clarify P.K. Khuntia. I mean,
all right.
Lordship may clarify the names. I am K. Khuntia.
Yes. In the course of the day, just providing the copy in the course of the day.
I'll do it in the course.
The appellant shall take steps for service of notice on the opposite, the respondents number 3, 4, 5 by registered post AD within 3 days from, within 5 days from today. Stop. Notice is made returnable on 2nd of August is a working day finder. 2nd of August 2023. That's all.
Item 13.
In this case, the writ appeal will be filed by the order, the order of the learned single judge arising out of family court proceeding by law. On the last occasion, there was a question raised by this Honorable Court with regard to the maintainability of appeal, whether the learned single judge invoked jurisdiction under Article 226 or 227.
Yes.
If it is 227, obviously not maintainable. If it were 226.
What according to you?
So, my lord.
Why is the jurisdiction of the learned single judge?
226, because my submission, respectful submission before your lordship, this is an inferior court, court of limited jurisdiction, family court. And for that I am
that issue. This right now we are discussing
yes,
Radhesham versus.
I heard that, my lord. I have got several decisions to that effect. That if it is a court of limited jurisdiction, then it is an inferior court, and if it is an inferior court, Article 226 certiorari lies. But if a lordship may see the scheme of the Act, my lord, Family Court Act, that the statement of objects and reasons.
No, don't go to the statement and objects and reasons only when there is an interpretation is required of any provision of the law, that we can go back to this object and reasons if there is serious confusion about the meaning of the provision. Otherwise, we are not entitled to look into the why the object and other thing that you have to get from the provisions first. That is the duty of the court as such. So just you read the section 19(1) first.
19(1)
of the Family Courts Act.
Yes, my lord. Save as provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure or in the Code of Similar Procedure or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order of a family court to the High Court, both on the facts and on law.
Yes.
Here I have challenged an order or interlocutory order, not the final order. Interlocutory order refusing for a conciliation proceeding. That is a mandatory, because the section 23 of the Hindu Marriage Act says every endeavor has to be made.
We are not concerned with the Hindu Marriage Act. Don't confuse us.
The conciliation proceeding.
Conciliation proceeding has been also provided in this Family Courts Act.
Yes, Family Court says endeavor.
Yes.
But Hindu Marriage Act says every endeavor. That means mandatory.
No, how when a matter is taken up by the Family Court, how they can go to the Hindu Marriage Act?
This is because the divorce is under section 13 of the Hindu Marriage Act, madam.
That we have already referred to in this larger bench in a matter where the limitation was being accepted under this section 28 of the Hindu Marriage Act, which says it's not permissible. All right.
I couldn't get it, madam. I'm sorry.
That the similar issue was issued when the court, any lease before the family court is duty to go by its own procedure. They can also devise their own procedure also. But they cannot. They can go to the civil procedure court that is provided in the Act. But they can say, no, I will follow the procedure of the Hindu Marriage Act. These are the two different ecosystems for adjudicating the matrimonial disputes. When the matters goes to the family court, they cannot go back to this Hindu Marriage Act. Though the provisions under section 13 is there, but this provision will be adjudicated under the provisions of the Family Courts Act.
And Family Court Act says the endeavor has to be made for conciliation proceeding.
That is there. It is a directory in nature.
No, I'll cite that. To that effect, I'll cite decision is mandatory. Because the court cannot.
No, yes, no. Apparently, it is directory in nature. If it was not done, you filed an application for conciliation.
Sorry, man.
Did you file the application?
Yes, ma'am. What has happened? 3 dates were fixed. First date, the opposite party appeared through virtually. The petitioner filed an application for his physical appearance. That was rejected. On the next date, that was the date when the court strike was there, and the Western Odisha strike was there. Link was not given to the petitioner, and the short date was it was adjourned to a short date. And the third date, since it was a very short date could not be intimated to the petitioner. The counsel for the petitioner took prayed for an adjournment. That was rejected. Court fixed it for.
So I got your point. That is, so you argue the jurisdiction under Article 227 cannot be exercised by the High Court in such circumstances. Right. If we only can, these other arguments we can consider if you can satisfy on this point. This is not coterminous. This is not a coterminus. It is first we are to that whether 227 has the jurisdiction or not. According to you, this is the mandate of the law to hold the conciliation. Yes, if it was not followed, whether it is a failure to exercise in the jurisdiction.
Yes, sir. Failure to, exactly.
Right. And
Right.
if it is a case of failure to exercise the jurisdiction, why it cannot be challenged under Article 227?
But both are quoted, 227 and 226, both are supervisory. So far as 227 is concerned, administrative also is there.
I beg to differ. 226 is not a supervisory jurisdiction.
226, the courts have held it is also supervisory.
No, courts telling that in a different manner. Then since it is a power of the judicial review, the court's hands are very long. They can touch every matter.
227 is very
But
wide.
when there is
Legal right is there.
No, again, there is an efficacious and remedy provided under Article 227. Why the court should exercise that power under 226 when there is no remedy? That if you can make out that kind of a case, obviously the court will not allow someone to be condemned without remedy. Then judicial review can be invoked. That's all right. But when the matter can be taken up under 227, what is your writ petition? Tell us. You filed under 226 only?
I filed an application mentioning, as your lordship said, both under Article 226 and 227.
Yes.
As per the High Court nomenclature, because any case is filed that cannot be filed under CMP, because CMP is only for
who is appearing against you for the Dr. Harinder Singh? Anyone was appearing in before the learned single judge, or
yes, before the learned single judge, the counsel was there.
All right.
I'll serve copies if your lordship says that. I'll serve copies on the other side.
Have you served?
Sorry, madam.
Have you served?
No, sir, not yet served because there's no direction.
No, they cannot. This is the problem, actually, what to do, because according to me, the order has been passed under Article 227 only.
My lord, the family court has been decided by 2011 Supreme Court, holding that it's a court of limited jurisdiction. And Naresh Mirjakar says, the decision says, if it is a court of limited jurisdiction, it is an inferior court, Article 226 lies. Hari Vishnu Kamath says 226 lies.
What does it mean by the imperial court? What do you mean by that?
Imperial court. Inferior court, my court of limited jurisdiction. That has been decided.
This is all right. Let us also see that decision. The first issue, the 2011 decision, a little bit, I do not know whether you have properly made the synopsis. Because the section 7.1 excludes certain jurisdiction. Excludes the certain jurisdiction means those matters are brought within the family court's jurisdiction, that will still automatically excluded from the jurisdiction of the civil courts. That was the purpose of section 7.1. How that can create a limited jurisdiction?
That they held it, then that is
whatever. We'll look into that. We'll look into that. Paragraph. You are referring to paragraph 17, 35, and 43.
Decision.
You are referring to.
I'll just place it, man. Paragraph 17, your lordship may see first. First decision. Paragraph 17 and 35. Your lordship got it, paragraph 17.
Yes, this is regarding judge and court.
Is a judge through limited, though of limited jurisdiction. Then again in para 35, it said it's a court of limited jurisdiction.
No, this is in what this court of definitely the limited jurisdiction, because it is not an ordinary civil court. This every term has a contextual connotations. This is a uniqueness of the language. So because limited jurisdiction means jurisdiction is limited to the subject matters which are assigned by section 7.
Only under section 7.
All right. Like other civil courts, any matter comes of the civil nature cannot be taken up by the family court.
Yes.
There is the restriction.
So it's a civil court kind of a plenary.
But all right. But how that helps you in just identifying the jurisdiction of the court against its order? If you are saying that if it is a limited jurisdiction, how does it help you? That is the question.
Because again, limited jurisdiction means it becomes an inferior court. Your lordship see page 867, para 35.
867. There are 35, so I told you this is a situation.
Thus, it is a court of limitation jurisdiction. Then, my lord.
Because of this which were given under the explanation, those will be the subject matters and will be taken up by the court. All right, then.
Then paragraph, my lord, 43, next portion, my lord, page 874. We start with 870, para 43. Relevant portion, my lord, in the middle of the first column, my lord, with the development of law. 871, left-hand column, middle, my lord, with the development of law.
Yes.
Your lordship, with the development of law, number of numerous tribunals and quasi-judicial bodies have been created to determine the disputes between the parties. Functions of such tribunals are primarily quasi-judicial and in the realm of civil jurisprudence alone. In other words, such tribunals or bodies exercise a very limited jurisdiction. It will not be appropriate to treat them as an inextricable part of the state judicial services or call them courts as understood in our constitution. Contesting parties appear before them because they give decisions which affect the right of the parties, and an appeal might be provided against their decision. Even the government in its
already show that decision. This will not help you. Show that decision when any court or tribunal is exercising the limited jurisdiction, their order is amenable to the judicial review under Article 226. Show such order.
That is the next decision, my lord. In the Mirjakar case, paragraph 64, 65.
In which, from the which report you are referring?
1967 Supreme Court. Second decision, my lord. Paragraph 64.
This is Rajendra Gatkar's decision.
A majority judgment, my lord, also followed by one concurring judgment by Justice Sarkar. In fact, I tried to search inferior court and there it is only this.
Right, just paragraph 64.
64.
No, the Rex versus Chancellor was sent once by.
Which is this decision? Year 1957 Supreme Court 1. Mr. Udgada, which decision? Which decision?
Second decision.
Don't say second. Say citation.
1967 Supreme Court.
Yes.
Yes. 1967 Supreme Court, page
Yes.
para 64 at page.
Got it.
18.
But in this context of this Family Courts Act, there is no difficulty in treating them as an inferior court. We have no difficulty. Problem is that in view of the decision of the 2014, this issue was considered by the Supreme Court. That is the issue, that where
my learned friend was referring, that is the case where they said only civil code.
No. They have discussed the law. Not only the civil, they are also discussing the tribunal also. Because there's a lot of confusion.
It's confused. That's a gray area, my lord.
But so people trying to now address this issue. And Ms. Mohapatra has also related this.
That's a case arising out of presiding a district judge, my lord. Mohammed case also arising out of case in the district judge, civil court.
All right.
That's a civil court, man. This is what I'm trying to draw a distinction, my lord.
And the tribunal is not a civil court.
That's right, but civil court, tribunal also, my lord, some cases. Even industrial tribunal 227.
That is why I'm asking you. Not only the court that they have restricted, they have also restricted the tribunals.
They have restricted, and
not only the tribunals, revenue boards, they restricted, that will be 227.
Revenue courts.
No, my anxiety is somewhere else. If really the conciliation was not done, definitely is a failure on the part of the court. But the process that you have followed, according to me, if it is not followed, it is a final order. So far the conciliation is concerned. Madhulimai versus State of Maharashtra, 1979 Supreme Court. What is the intermediate order? What is interim order? What is the interlocutory order? Section 19 only restricts the interlocutory order. But this is the intermediate order. In the proceeding, a final order has been passed. This will never will look back again. That is the problem. But I understand if I can, we are thinking of it differently, but this is the real problem because if it is 227 for whatever purpose, then we cannot pass a single order. We have to observe this is not meant to be. Because this decision of 2015 says the letter patent appeals is prohibited under the constitutional scheme from any order passed under Article 227.
And then Supreme Court also gave a line, my lord. Observed, my lord, how
So
it is to be.
what we do, I think today is we have a very congested board because of we only sit in the first session. We fix the matter on any other day. All right. We are returning all the materials you have supplied to us. You just place it again on that day. We will fix it on 7th or 8th, 7th of July. I'll let the matter be listed again on 7th of July. On that day, we request the counsel for the appellant to make incisive submission on the mentionability of this writ appeal. As apparently the order challenge in this appeal shows it was passed under Article 227 of the Constitution of India. We are using the word apparently, so you have a scope to show this observation is not correct.
Here, what happens, my lord? Initially, the matrimonial case was filed in Rajasthan. That was transferred to Jharsuguda by virtue of an order of the Honorable Supreme Court. While directing so, the Honorable Supreme Court said that endeavor to be made to be completed within a period of.
And I'm telling you one thing, that what we are observing, this thought is traveling through my mind, that we dismiss your petition by clearly observing that despite the rejection by the learned single judge or by us, you'll be entitled to file an appeal, and the time that you have taken to pursuing all this proceeding will be deducted when we'll be considering the limitation. That is an alternative thought. It came in my mind. You also think over that.
Right.
All right.
May I prepare an interim order when the stay of person.
So nothing would happen because the 7th only. You tell that court that nothing would happen because
if an application for adjournment will be filed, that can be taken. That your lordship may observe.
All right. Before that court, nothing would happen, I think. Yes, on 3rd July 2023. Mr.
22, 23.
Additional government advocate has appeared for the appellant. Right.
2 matters.
3 matters. 24 also, I think.
24 is on 24.
24
23 and 24. 22 and 23.
I am 22 and 23.
All right.
Both will be taken on 3rd July, 24th.
24.
In item 24, my lord, I am appearing from respondent, my lord. Copy of the writ of
Hold on just a minute. Who is appearing for the appellant?
The state is appellate, my lord. State has filed this, my lord. Whether provisional pension should be allowed during pendency of the criminal proceeding. It's not, criminal proceeding is still on. He has been superintended in the meantime, and this honorable court allowed the provisional pension. So we have challenged that provision.
You have challenged that.
You want full pension to be paid out?
We are dismissing your appeal.
No, my lord, let it come.
Dismissing your appeal.
No, my lord, let it come another day. I'll apprise the lord.
Supply her a copy of the memorandum of appeal.
Because the rule also says that if there's a grave misconduct, then the pension can be withheld, ma'am.
Therefore, that is notice to be issued to the person. You have not issued any notice.
I'll take instruction in that. We actually.
All right. The request of this is 24. Ms. S. Patnaik, additional government advocate appearing for the appellant. Let the matter be listed on 5th of July, 2023. Stop. Your good name?
Babita Kumari Patnaik.
Babita Kumari Patnaik. Miss Babita Kumari Patnaik, Land Council, appears for the respondent number 1 and 2 both. No, one respondent number 1. Just we are not reflecting. You supply her a copy of the memorandum of appeal because we'll hear the matter on next date at the admission stage finally. We are not reflecting it because we have not issued the admission notice. That is, we are not asking you formally, but supply a copy.
We'll do that.
Come on the next date, it will be hard on merit. You also prepare yourself properly.
25.
Well, you'll actually fix the date.
5th of July.
Can it be on 10th of July?
No. Someone is not getting anything from you.
Pardon me. Item 22 matter is kept to 4th. Can be little bit earlier. The son of this particular is suffering. Son, and he is costing about 12 years, 6 months. I'm sorry that I have reached late, but
it is 21. So we fix on 3rd of July. The request of Mr. Manas Chand, Land Council, appearing for the appellant. I did just change. That the matter be listed on 3rd of July 2022 for consideration of
petition.
IA number 656/2022. All right. Mrs. Patnaik, that is there. And council has appeared for the petition. Yes, next.
25.
25, my lord. The present writ appeal has been filed challenging the order of the Honorable Single Judge, my lord, wherein the Honorable Single Judge has directed for regularization of the present respondent number 1, my lord. Here, my lord, the status of the post which was created as a contractual post, my lord. And the present respondent, my lord, although it was initially appointed in the year 1998 on contractual basis without any sanctioned post, in 2007, the 21 posts were created as contractual post. And accordingly, the present respondent number 1 was absorbed against the contractual post, my lord, with certain terms and conditions that she will never claim any regularization in her future.
That is a forget about that claim of the regularization. We know the situation in the employment market.
My lords. And my lord,
it is the bargain between the two persons who is dominant and another doesn't have any right to bargain also.
My lord, here is a case that.
No, my question is whether there is a scheme for regularization.
Well, there is no scheme for regularization, my lord. There is no scheme for regularization.
Or equal post of that nature.
Well, nature of the post is, my lord, contractual.
That is why the petitioner seeks regularization.
No, my lord, here is not the case that against a regular vacancy he has been appointed contractually.
Then he would not have come to the court.
In the cases, in some cases, my lord, against the regular vacancies, employees are being appointed on contractual basis, my lord. Here the post itself is a contract.
This kind of practice is there anywhere.
And
so against some regular post, because this is completely a different kind of post. Anyway, we will examine the matter. Who is appearing for the petition?
I am appearing for the respondent number 1.
We are fixing the matter on 4th for final disposal.
I just want to draw your lordship's attention on only small point. Your lordship may please to have a glance. The matter was heard on merit and last order dated 4th May 2023. This matter was heard on merit by the another division bench by Honorable Justice Chief Justice and Justice S. G. Satpathy. Therein, their lordship directed consider that counsel in appearing for the respondent number 1 on advance notice point of the respondent number 1 would not stand covered by the first part of the order dated so and so passed by the Supreme Court of India in SL. The facts remains that on the same date in the year 1996, the present respondent number 1 along with 3 others were appointed as junior assistant. And thereafter, they are regularized against the contractual vacancies. Thereafter, posts are there, was created for regularization, annexure 11, page 50. Clear vacancies was there.
First, whether the post was created for their regularization.
Thereafter, this honorable court, this honorable single judge directed that over continuing for the last more than 25 years, this is a fit case, their case should be considered for regularization. And identically out of 3 persons, in 1 person's case, this honorable court in writ of appeal confirmed the judge of order of the learned single judge that order was went to Honorable Supreme Court. And the Supreme Court, by order on Annexure 5, also upheld the order of this honorable court. Persons similarly situated out of 4 persons, in 1 person's repeat same order. Appellate court upheld.
All right, we will finally hear the matter in the admission stage. Come prepared on the next date. Let the matter be listed.
Last order, my lord. My lords are directed me to take instructions. My lord, I am filing those instructions by way of an affidavit. May I be permitted to file in the court?
All right. Serve a copy on him also. Listed on 7th of July is possible. 7th of July 2023. And this appeal will be heard at the admission stage, considering the nature of the controversy raised in the writ petition. Mr. S.K. Samal, Learned Counsel, has appeared for the appellant, and Mr. D.K. Mohanty, Learned Counsel, has appeared for the respondent number 1. Yes.
26.
My lord, I am filing those similar matter, my lord.
Same order. Next.
27.
There is a delay of 16 days in filing the writ of appeal. So notice has to go, my lord, to the party.
Now, what is the subject matter?
Subject matter, my lord, this is regarding appointment of Anganwadi worker. The advertisement shows that he should have the knowledge of to write, read Odia, speak Odia. The party who has been given appointment, she doesn't have the basic qualification of Odia.
All right, we are issuing notice. But why then this your writ petition was dismissed?
My lord, 2 writ petitions were filed challenging the order of the ADM. ADM cancelled the entire process on that ground only, as because the fake certificate was filed by the respondent number 6. That she has passed ODI. That was found to be fake. Keeping that in view, entire process was cancelled. I have filed an appeal and the respondent number 6 also filed an appeal. Both the appeal were heard together and 1 judgment was passed, directing that opposite party number 6 knows the ODI to speak ODI and also knows ODI, which is not the requirement. Requirement is she must write, read, and speak ODI.
What is that requirement? Have you
Requirement, my lord, advertisement, that is Annex 1. It is in ODI. The lordship may kindly turn to page 11. My lord, Justice Roth, last portion.
No, you have to
supply this translated version.
I'll supply.
Constitution says the court language is English.
That is true.
And depending on that, we are transferred to a court. We do not know the local language.
Also, Supreme Court says that in every local language, the judgment.
Encouraged. And if you want to encourage the local language at your cost, I have no difficulty. I will say I do not know anything what is written there.
No, then I supply my. No
All
problem.
right. 3rd of July.
3rd of July, I will supply the.
Just
Because here the proper translation is necessary because what is the meaning of that clause? Exact
Yes,
meaning.
yes.
the request to Ms. S. General and Council appearing to the appellant, let the matter be listed on 3rd of July.
Oblige. Both the matters.
Meanwhile, Ms. Jana shall invariably supply the verbatim English translation of Annexure 1. Same order in the next item also. Anyone is, Mr. Kunti, are you there in this matter?
Yes, Mala, I am here.
Mr.
In this
Kunti, Additional Government Advocate appears for the state.
29.
Oblige.
May I please, your lordship. My lord, here, my lord, I am challenging the order passed by Honorable Single Judge, order dated 23/3/2023. My lord, kindly see by Annexure 3, my lord. I have filed a writ application before the Honorable Single Judge against the
3.
order of the.
Are you sure Annexure 3?
My lord. My lord, Annexure 3, page 18, 18.
Huh?
18.
It's all right. Are you sure that is Annexure 8?
3, my
Next
lord.
order will be the
3,
same
my
order will be replicated. No? Next
Annexure
case.
3. my lord.
Just you come to the writ appeal first.
My lord.
Index.
My lord.
Annexure 3 is the input order.
Annexure 3, my lord.
Yeah, this not been put in the page mark. All right.
Here, my lord, without assigning any reason, my lord, my writ application was rejected, my lord. My writ application was filed against the order passed by Permanent Continuous Loko Adalat, my lord. In Permanent Continuous Loko Adalat, my lord, the present appellant number 5, my lord, filed a.
What do you mean by permanent continuous Loko Adalat?
My lord, permanent continuous Loko Adalat, my lord, where both the parties filed the compromise.
No, I am asking you, there cannot be such forum. Either there can be the permanent Loko Adalat or the continuous Loko Adalat. These are two different jurisdictions exercised. So which one? Who passed this order?
Permanent continuous Loko Adalat.
Again, you are going to the permanent continuous Loko. There is no nomenclature in the Legal Services Authorities Act. You read section 21 and 22 and start reading from section 19.
My lord, 21 award of Loko Adalat, my lord.
That is of 19. Now then go to the section 22.
My lord, power of Loko Adalat or permanent Loko Adalat.
Yes.
But my lord, I have filed the application
because
under
they
this
have
scheme.
two different ecosystem and jurisdiction. Try to understand what I am telling you.
My lord.
Permanent Lok Adalat only given the jurisdiction to the public utility services, no other matter.
My lord.
And Lok Adalat means they cannot exercise their jurisdiction without any settlement. Right? So what is your problem? Just read this part of page 21. Come to page 21. You filed a compromise petition before the Lok Adalat.
My lord.
And now you are challenging that order.
No, my lord. Only I am challenging the order only on the ground that compromise has duly decreed, my lord. But the sketch map was wrongly drawn up, not according to the compromise petition, my lord. Only the map is wrongly mapped, my lord. The sketch map. So only on that ground I filed this writ application.
No, where is this come to the writ appeal? Where is this ground? I did not come across that ground. Show me the ground.
In my writ application, my lord.
Yes, no, writ appeal.
Writ appeal, my lord. No, only I have taken the that I have not taken.
That is not the way to draw a memorandum of appeal. You have left the main ground on which you should have challenged that.
Paragraph 7, you have just given the
description.
that what happened. Paragraph 7.
My lord, paragraph 7 on 1/2/2023 when the
Order 41, rule 1, you go. Regarding the power of the court, unless the ground is taken, whether the court can touch on that ground any appeal.
What is this? What? This is your ground. Why were you in such a hurry?
My lord, sorry, my lord, I have not.
You file an application seeking leave to add some additional ground. Let the matter be listed on 7th of July. That's all right. But you have to take that ground also. Though the writ petition was dismissed at the threshold on other ground, Mr. SSK Naik, Land Counsel for the appellant. So in the meanwhile, the necessary steps as required to incorporate the pertinent ground may be taken. No further recommendation will be made.
Obliged.
You have to share with me the part of your fees because I am counseling you. Okay, next.
Obliged.
I think other matters cannot be taken up.
It has been rejected on merit. It has been rejected on merit. Your ground is totally.
So there is a ground, my lord. Another point.
No, anyway. Take proper grounds.
The other matters will be taken up 26th or 27th. We'll be distributing these cases, leftover cases, either on 26 or 27.
My primal item 32. I primal 2 is time to file rejoinder.
32. 32.
I'm the petitioner. I've
All right.
also taken consent.
And the request from Mr.
No,
is 32. Mr. D. Mahapatra and counsel appearing for the petitioner. Let the matter be listed on 21st of July, 2023. 21st of July.
My lord, order to continue. My lord, item number 33.
Just
Order to continue.
Meanwhile, the petitioner may file the rejoinder, if any, but no further recommendation will be made for the same.
My lord, in item number 33, that blood bank method, I was directed to file an affidavit on locus standi. Today I am filing. My lord, I may be permitted to file and I am serving copy to the state.
All right.
Item number 33. Item
32 will be
Lord,
also.
may I have, my lord, I'm on virtual, my lord. May I have your lordship's indulgence for item 62, my lord? And my video is paused by the Honorable Court Master, my lord. Therefore, I'm unable to come on the screen. Item 62, my lord. I appear for the respondent 3 and
Your lordship. Just wait a minute.
Open it.
I don't think it has been stopped by the court.
My lord,
Yes,
I'm obliged. My lord, I'm on item 62, my lord. I appear for the respondent 3 and 4, my lord. I have filed the counter affidavit today.
All right.
Your lordship,
May I pray any time in the first week of July?
item number 62.
You're appearing?
Yes, your lordship. And
I
your
will
lordship,
serve the copy of the counter.
Have you received the copy of the counter?
no, your lordship.
I have not served it yet, my lord.
What? Without serving, how can you file the counter affidavit?
My lord, I'm in the process of filing during the day, my lord. We just
All right,
filed during
you made a submission that you have filed the counter affidavit.
in the course of the day, my lord. That was my submission.
And what kind of a submission? I am in the process of filing the counter affidavit before a court.
I'm very sorry, my lord. All I'm seeking is that the matter be called in the first week of July, my lord.
Your lordship, pardon, your lordship.
He has
Lordship,
not filed.
OP number 2 has filed an affidavit, the minutes of the meeting, which has been convened under the chairmanship of OP number 2. And they have filed an affidavit, and today I have filed an objection to such affidavit.
All right, we'll take up the matter on 4th of July again.
May I repeat my item 32, interim order to continue.
32 just interim orders. As per leave shall continue. In item 62.
32, your lordship fixed a date, man, 32.
21st of July.
Obliged.
My lord, item 35.
Just 62, let me pass the order.
My lord, item 35.
Mr. Just 62 order is being passed.
Mr. So in this, you are appearing to the you are Mr. Das.
My lord, Aditya Das for OP number 3 and 4.
Mr. Aditya Das, counsel appearing for the OP number 3 and 4.
62, you'll appear today or what? Or name appear?
Has submitted.
You're entering appearance today.
Submitted that the affidavit will be shortly, counter affidavit will be shortly filed. Let the matter be listed on Don't post any matter. Let the matter be listed on 21st of July 2023. You are appearing for this petitioner?
Petitioner, Mr. Obinus Swai.
Mr. A. Swine, counsel appearing for the petitioner, has submitted that. He has
Lordship,
filed-
today I am filing an objection to the affidavit.
Oh, you have also not filed.
Today I am filed.
All right.
Let them share the copies. That's
That the petition will file an objection. In what matter you file the objection?
Objection to the affidavit, that is the meeting which has been convened
All right.
as per the direction of the Honorable Chief Justice.
Affidavit. All right. Mr. Das, have you filed the Vakalatnama?
My lord, it's been filed today in the course of the day as well.
Meanwhile, Mr. Das may file the proper Vakalatnama. All right.
May I see item
61.
Obliged.
61.
My lord, may I pray for 61? Any date may be on Monday. It's a photographer's association.
All the pages let them.
No, not next week. It will be there next to the next week.
It's 26th, my lord. May I pray for 26th? Because
No,
the law and order situation is going on. The Konark temple matter, my lord. The
Here also.
All right, let us try it. Let the matter is 26th.
Obliged.
Item 62.
61, man.
61, yes.
Obliged.
Mr. MK, at the request of Mr. MK Das, appearing on me, you are appearing on behalf of Mr. Shiv Shankar Mohanty.
No, my lord. In writ appeal, my lord. Yes. Wrongly, the writ application was there.
Appearing for the, you are appearing for whom? Opposite party number?
Where the licensee interveners, where the licensee under the ASI.
License on
He is the intervener, we are for the opposite parties, other petition counsel, other side is there.
Yes,
They are not before my.
I'll let the matter be listed on
26th.
26th June 2023.
26th June.
Monday. Who is appearing for the petitioner in this matters? 61.
Respective council may not reach that, so that's why they may not be there because we are accidentally.
I will intimate, madam. I will intimate.
All right, on 26. Just only this, all the matters on 26. Same order you passed. One line order.
My lord, item 35. Item 35. The advocate for the respondent met with an accident yesterday. This may be taken up some other day. Today he communicated to me about this.
35. The order has been passed in 35.
No.
You are appearing for the petitioner?
Appellant.
Oh, appellant, yes. Who made the accident?
Mr.
Appellant.
Santosh SK Patnaik. Santosh Kumar Patnaik for the respondent, my lord.
Oh, it is
Senior
reported by.
Yesterday.
You are Mr. Jena?
I am Mr. Jena.
Reported by Mr. K. Jena and counsel appearing for the appellant that the counsel for the opposite party number or the respondent number?
Respondent. I am appearing with him. I am on behalf of
the respondent.
Senior counsel who is.
I am for the opposite party number 1.
Mr. P.K. Patnaik, is a senior counsel?
No, SK Patnaik.
SK Patnaik.
Mr. SK Patnaik.
Senior counsel.
Plus his senior counsel is met an accident and as such is not in a position to attend the proceeding today. Let the matter be listed on 18th July is all right? All right. 18th July.
18th July.
Pardon to mention item 60 million. But item 60. In that matter, rule 22, group Odisha, group B, C, D has been challenged. In which they have item 60 million.
60.
Yes, million. In that
those
case,
matters, I think, We have on similar matter.
Yes, my lord.
So fixed on 24th of July.
No, that is first time. Tomorrow, yesterday, that matter has come first time. In our matter, notice has already been issued. Now they have published SOP. And now they are going to implement that rule.
That is the reason we have preponed the hearing on 24th of July, next month, 24th July.
No, this is the first batch, Lord. Our case is the first batch. Yesterday, your lordship has fixed that matter first time that has come.
Notice was issued for the first time.
Then all the matters will be tagged together.
Yes, my lord. If this matter will be heard earlier.
But SOP, if the SOP is implemented, how you are affected?
Because they will be regularized from their initial date. They are appointed as per rule 13 and 2013 and 14.
Do you think the court doesn't have any power to give the implementation from that particular, if we held the rule is not this?
For that reason, I have filed an IA. That IA may be taken up and any decision subject to.
Okay, any decision subject to final outcome. Okay, list this matter on 24/7/2023 when the analogous matters are fixed by us for hearing. Stop. Item 50 to 72. No? Huh? The list. Stop. You are also appearing in all these matters?
No, my matter is 60,
All
62.
right. It has been 60
and 50 also same. 50.
Already in 50 is tough in all the matters. In the meanwhile, if any appointment in terms of the standard operation procedure is made, such appointment shall remain subject to the final outcome of this writ petition.
I may pardon, my lord. Item 47. I am for the appellant, my lord. There is an interim order. Interim order to continue till next day.
All right, then give a date.
Mr. Raut, where is you have a IA? Have you filed an IA?
Yes. 9444.
When?
Today I have filed.
Where?
Today.
Today, where have you filed?
In the counter. IA number is 9244 of 2023.
You are appealing for the appellant, Mr. Mohanty.
Yes, madam. Item 47, madam.
Huh?
Yes, ma'am.
Let the matter when can be listed?
18.
Let the matter be listed on 18th July 2022. So, interim order is passed earlier shall continue till the next date. Mr. A. Mohanty and counsel is appeared for the appellant.
My lord, item 38.
44, my lord. As an interim order, my lord. May we take up any
date?
My lord.
18, same order, huh?
My lord.
Item 38, my lord.
44. You are there?
My lord, I am for the petitioner, my lord.
SS Sahu.
My lord.
SS Sahu, huh? Same order, just change the name of the council. Yes.
Interim order, my lord.
It will continue.
Item 38, my lord. Interim order continue and kindly adjourn to some other date, my lord.
Two matters.
Item 38.
One has been not done, I think. 38
You are there?
No.
I am Pratima Das, my lord.
The 38 we did not pass any order.
38, which item are you there? One or two?
Item
38, there are two matters.
What is the purpose of their mentioning?
Alok Kumar Poti, 19482.
She was asked to mention when the matter reaches because the connected matter was there. So opposite party is here also.
We just today there is no time. We are fixing a date. We are fixing a date, next date. 18th July. All right.
I am for the opposite party.
No, this let the matter be listed on 18th July 2022. In the first case also there is an interim order. Can you say us this item 38?
Yes, my lord.
There,
Hash question, I second.
Is a common order has been passed. Interim order, if any, is passed earlier, shall continue. And the next sub item, 19482, huh? Same order. You are there on record?
Yes, Madam.
What is your name?
Madam, in the
Pratima
second
Das,
case.
P Das.
P. Das, MS.P. Das, non-council appears
Second case, first is
for
only
the
there, only
petition.
Mr. Napata is there for the OP.
In the first case, Mr. D.K. Mohapatra, non-council appears for the. Yeah. This is the opposite party number. Can you say right now?
One. In the second case, one.
Second case, one, first case.
Opposite party number 4. In the second case,
One.
for opposite party number 1.
Obligation.
I remember it will come on 17.
18 July.
18 July.
18.
Obligation.
So let other you distribute, just see the interim order is there. If interim order is there, continue the interim order.
I think I'll go whatever.
Call the judgments.
Let's know.
Item 1.
May I please use? I am for the petitioner, my lord. And my learned senior is for the opposite party. My lord, I granted 10 days time to prepare because the judgment, he has raised a question that the unstamp agreement of the arbitration, which has been decided by the Honorable Apex Court recently. That is 298 pages judgment. So I require more few days time.
It's okay. But it is now ready for hearing.
Yes, ma'am.
Notes are exchanged.
Dismissed once, restored.
Yes.
There is the pertinent question that has to be answered, ma'am.
You are Mr. K. Guru.
Yes, ma'am.
Mr. K. Guru, learned counsel, appearing for the petitioner, has advised this court. The larger bench of the Supreme Court has decided the reference for that purpose. Now, as he like to place the decision of the Apex Court on record, he needs some time. Precedence allowed. Let the matter be listed on 18th of July. Stop. Meanwhile, the judgment of the Apex Court, as noted above, shall be placed on file.
Yes, ma'am.
Mr. Sanjeev Udgatar and counsel is appeared for the opposite parties. Or just only Friday. Give the date on the Friday.
18th is not Friday morning. 21st is Friday.
21st. Okay.
Item 2.
Item 2, today we are filing this counter affidavit to the arbitration application, my lord. 2 and 3 both.
I am
All
my lord, I am for the petitioner.
No, all right. That's they are filing the counter affidavit today.
My lord.
So we'll be granting them some more time. Fixing on next Friday.
My lord.
Next week, 7th.
7th of July.
My lord.
Mr. P.K. Paril and counsel appearing for the opposite parties has submitted that the counter affidavit will be filed in the course of the day.
No, we have already filed in online.
Oh, the counter affidavit has been filed. So since the
Hard copy you are filing here.
Since the said counter affidavit has not been placed on record, you have got the copy?
Today I have received. Just now.
Stop. Let the matter be listed on 7th July 2023. Mr. Nilkanto Jujar Singh, one counsel has appeared for the petitioner. Already.
2 and 3. Item 2 and 3 both are the
Same.
Yes, yes, both are same, yes.
Okay.
Mr. Kashyap is appearing with me, let me reflect along with me, Mr. S.S. Kashyap.
In both the cases?
Along with me, yes, Mr. Kashyap, Satya Sindhu Kashyap.
Learned counsel, learned CGSC.
CGC.
CGC,
My lord.
Already. There is a senior panel also, I think.
There is another senior panel, that's why I am classifying.
Okay. Next.
Item 4.
Oblige.
May it please your lordships, my lord.
Lord,
Counter your lordship.
My lord,
Serve the copy also, your lordship.
my lord, the petitioner,
Yes.
the last opportunity was granted to them, my lords, to file their counter. Now, my lord, they have served us with a counter just 5 minutes back, my lords. I am ready to argue the matter. In the counter, my learned friends have made out our case very simple. They have not decided, they have not challenged the existence of the arbitration agreement. So, my lords, the existence of the arbitration agreement is not, my lords, disputed. If your lordship takes up their counter affidavit, my lords, because I'll to show your lordship the arbitration clause and what do they say about in their counter affidavit. Their defense, my lord, your lordships kindly sees paragraph 5. Paragraph 5 of my lords.
If your lordship pleases, your
Kindly,
lordship.
yes, my lord. Kindly sees, my lord's paragraph 12.
Your lordship pleases, I have filed the counter today, your lordship. A written note and along with a note of submission with judgments, I may be permitted to provide.
You need time.
Yes, your lordship. Only because, your lordship, here is a case where the petitioner have challenged this same cause of action before NCLT, before in a criminal case. They have so moto appointed an arbitrator, which I refuse to go. Then they have come here, your lordship, with the same cause of action. For that,
May I clarify? May I clarify?
Just wait.
Yes, sir. Paragraph 12 is where they say about the dispute, my lord. They say that they want to return the money. If your lordship kindly sees paragraph 12, and my lord, paragraph 12, my lord, your lordship sees, my lord, subpara 9 and 10. And then, my lord, at para 13, they say,
No,
lord, this
just
is
I want to know there was a settlement and which has been reduced in writing in a draft agreement. And in terms thereof that you have already deposited this 2,17,000.
2 crore 17 lakhs I have been depositing every month. I am waiting for.
There is.
So
May I indicate?
What is that agreement?
That is an agreement after the MOU was.
Now, whether that agreement, this payment that you are making by installments is a part of that agreement, which has
subsequent agreement, it was understanding.
Having impact on this the agreement where this arbitration clause is there.
It is an agreement. The agreement clause is there to supply share certificate, your lordship, and some raw materials was to be purchased from them, your lordship. Because there was some faulty raw materials provided by them, I refused to take it, and I said that I will return the money. And in that pursuance to that, I have been returning the last 2 years, your lordship. But they have on the same agreement. They have challenged before the NCLT that the share certificate should be implemented. They have initiated 2 proceedings of criminal nature, saying 420 IPC 420 they have been invoked. That has been stayed by the honorable court, by this honorable court. Then this proceedings, your lordship. So the same cause they have been forum hunting has been going on, your lordship, and they have been receiving the amount.
Lord, may I answer that?
But perhaps they have not invoked this arbitration clause.
Yes, my lord. Yes, my lord. Yes, my lord. My learned friend would allow me to place my
No, just for embarking on the criminal proceeding or for any other proceeding under the company's laws.
Yes, your lordship.
Can someone is debarred to invoke the arbitration
for that
clause?
matter, I am not there, your lordship. Debarring or I need to. That is why I pray, your lordship. Some
that will change the character of the dispute. That much maximum that can happen.
My lord, let me clarify.
Also, once they, if a dispute is there, once they accept the money, your lordship, then the question of going to arbitration.
That is why I am asking a very single question: the draft agreement, whether it is impacting.
It is, your lordship. Once they accept it, then it is impacting.
That is what.
That is
what. So we are answering the matter of 7th council. Just a little bit. Since he needs to file certain note, we'll give them a short opportunity. It will be listed again on 7th July.
My lord, I am so grateful, my lord. Your lordship just gives me 30 seconds, my lord. If your lordship kindly, my lord.
Sure.
Yes, my lord. I am so deeply obliged. My lord, here is a case. There was an MOU for, my lord, to transfer the shares of the company. My lords, 2 my lords, the petitioners. Well, money paid to them. This MOU has an arbitration clause.
Yes.
Money paid to them, shares not transferred. Well, the first remedy is, well, your lordship knows, under the Companies Act, to apply under section 59 of the Companies Act for before the National Company Law Tribunal. That is regarding the shares. There they opposed. Now, when it came to opposition, there's a clear case out of fraud. So criminal case was filed under section 420.
Just take a little pause.
Yes,
here.
yes, bro.
The money that they have received by agreement, subsequent
Yes.
agreement, they are
Not
refunding the
subsequent
money by
agreement.
installment.
No. That is exactly what the dispute is, Malad. For the last 2 years, there is no draft agreement after this particular agreement in question. Let me clarify that. There is no agreement in question. Kindly sees their counter. Kindly sees, Malad, their counter. There is not a single annexure to this particular counter. What do they say, Malad?
Come to page 5 of their counter.
Yes, Malad. Yes, Malad.
Page 5 and the para 12, this sub para 4.
That's Malad. Yes, Malad. Yes, Malad. Malad, I am with paragraph 12 in pursuance to the said drafted agreement. Yes. There is no drafted, there is nothing annexed because there is nothing, no signed agreement between the parties except the MOU. The opposite parties have refunded a significant amount.
Counsel for the opposite parties, they raise the questions that you are accepting that money.
No,
they
Malad, if my learned friend says that he wants to refund the money to me immediately today, Malad, there will be no need of going for arbitration. But in arbitration,
that is what exactly that he wants to just clarify that position also.
Malad, that's what I'm trying to say, Malad. I will have a right to claim even damages for the breach of contract on his part.
That is a separate issue.
For which I have to go to arbitration, Manoj. I have to go to arbitration. Well, that is why I have invoked the arbitration clause to claim damages, to claim the money refunded from him. So, Malaj, which is why he says, kindly sees page 7, Malaj, kindly sees page 7. Page 7, paragraph 14. Kindly sees paragraph 14 at page 7. Yes. That in the facts and circumstances of the case, the opposite parties are always willing to settle the outstanding dues, along with interest to which the parties also agree initially. And the same is well established from the very conduct of the opposite party by way of repayment that is being done till date. Therefore, the opposite parties be allowed to return the remaining as had agreed by the parties, and the present petition may be. So he agrees this dispute, he needs time to refund this money. Yes. This has to be adjudicated by the arbitrator, Malaj. Today, my learned friend cannot today resist an arbitration proceedings on the ground that section 59 proceedings are pending before.
Just wait. Don't take this so far off from this point that if you agreed that this can be settled by this understanding, why the arbitration?
I did not agree to any settlement. Because I want to claim damages from him. I want my money along with interest from him.
Already the matter on merit on 7th.
Very well.
The counter affidavit has been filed by the opposite parties today. Stop. Let the matter be listed on 7th July 2023 for hearing. Mr. Rishabh Banerjee. You are Mr. Banerjee, who is appearing for the petition? This petition.
Yes, Malad. Yes, Malad. Yes, yes.
You are Mr. Rishabh Banerjee, Learned Counsel appears for the petitioners, and Mr. Vaishabhat Panigrahi. Panigrahi, Learned Counsel appears for the opposite parties. Stop. Whether any of the parties has filed the agreement?
This agreement has been
Malaj, we have Malaj. MOU kindly sees Malaj. The MOU is at page.
But the drafted agreement has not been. The supplement drafted agreement has not been filed. I'll file it for MOU also.
Already in the meanwhile, the agreement under reference be filed. Have you just formulated your dispute, Mr. Banerjee?
Yes, Malad. Just one clarification before what my learned friend says. The agreement under reference is the MOU, which is already annexed at page 18.
Already is there.
Yes, Malad. Page 18, Malad. Lordship sees page 23.
No, if that is there, it's all right.
Yes, Malad. I mean,
subsequent understanding which has not been signed, in pursuant to which I have been paying your lordship at the rate of 18% interest, and they've been accepting that, I will file your lordship.
They're all right. You file it. This is not required. The agreement and reference is already on record. Mr. Banerjee shall also file the disputes, frame the disputes in a separate sheet to present it before in the proceeding. You just say in a separate present the proceeding.
I'll do that.
An
I'll do
advance
that.
copy of that this statement relating to the dispute be served on Mr. Panigrahi in advance. All right. That I'm not writing your note, you will submit, you can submit it. It is always there. Yes.
Item 5.
Since my learned friend has used a reply today, and a rejoinder opportunity was initially granted to me, since your lordship is adjourning the matter, may I file my rejoinder also in the meantime, if required?
In the
Yes,
meanwhile, the rejoinder may be filed by the petitioner, but such rejoinder shall be filed by the 5th of July 2023.
Deeply obliged. Deeply.
What about 6?
So great.
5. Yes.
If I may please your lordship, your lordship, the conducting council is not present at the moment. If I could seek for a time of a week.
All right. This you are appearing for whom?
I'm appearing for the petitioner, your lordship.
No.
Satyakam
Swain?
Aishwarya Ere.
What is your name?
Aishwarya.
Miss A. Royal Unit Council appears on instruction of Mr. Satyakam Swain.
Yes.
For the petitioner. Urges short accommodation. Such is the accommodation which I grant. Let the matter be listed on 7th July.
Much obliged.
2023.
Appearing for the opposite party, my lord. And in the meantime, we have filed our response affidavit on 15th May. That is not taken to record. Lordship may direct the office to verify, my lord.
All right. Mr. Devashish Tripathi. You are Mr. Tripathi, I think.
Yes, my lord.
CGC appearing for the East Coast Railways has submitted that the reply affidavit has been filed, but that has not been placed on record. Rest is to verify. Stop.
And a copy may be served on us.
You have not received a...
We have not received a copy.
I will serve to her tomorrow. By tomorrow.
Mr. Tripathi also ensured that copy of the said reply affidavit is served on Ms. A. Royal and Council appearing for the... You are there on record.
Yes.
And counsel on the petitioner.
Tomorrow is Saturday, let it be Monday.
That part you just told it, huh?
That may reflect Monday because tomorrow is Saturday, Monday.
By Monday.
All right, supply, I have not specified date. Supply positively by 26.
Yes.
26.
Yes.
Supply it.
Item 6.
Yes.
Item 6, my lord, I am for the opposite party. We have instructions to appear on the matter today, my lord.
All right.
I kindly seek some time.
You
my
file
lord.
the reply?
My lord, I'll file the wakalatnama in the due course of the day. I'll take instructions with regard to the filing of counter, my lord, in this matter.
We are fixing the date on 21st of July. Friday. File the reply, there will be no further opportunity.
My lord.
At the request of Ms. S. Ghosh.
Apal, my lord.
Apal, sorry. Apal Council. You are filing wakalatnama?
My lord. I shall file it.
It appears an instruction of the opposite party has submitted that the opposite party will file the reply affidavit and hence an accommodation be provided. Residence allowed. Release the matter on 21st July 2023. Meanwhile, Ms. Epal shall file the duly executed wakalatnama. All right.
Item 7.
Lords, I am appearing for the petitioner, Lords. It's an application for appointment of arbitrator, Lords. There were 2 agreements.
In this matter, may I submit, my lord, on behalf of Mr. Satyasudhar Kanungo. He is indisposed today. He's prayed for a short adjournment to file a short reply, my lord.
So I just giving a short time. It's 7th of July. You are Mr. Chopra.
My lords.
At the request of Ms. S. Patnaik and counsel appearing on instruction of Mr. S. Kanungul and it counsel appearing for the sole opposite party, that the matter be listed on 7th of July 2023. Meanwhile, the opposite party may file the reply affidavit. It is made clear no further accommodation will be made. So Mr. Vivek Chopra and counsel has appeared for the petition.
Great.
Take this on record.